sanction is basically a restrictions can be imposed on the both the sides of the assets, which is tangible and intangible. And in the assets, we mean is related to the hard currency. It can relate it to the matter of the assets, or it can be of a goods and other things. In the intangible format, it can be an insurance, it can be service, and it can be any kind of a designs and other things as well. Now, further, just to put a structure to it, what exactly the program contains? The program contains can be possibly a targeted country, targeted individual, or an entity. Sure. Shrini, just for reference, because we are picking up such a vast topic, I have prepped like an anecdotes. You pause me whenever you find it. It's going overlay because as we speak, yesterday night itself, there is another new sanctions have been applied on Houthi and other things are happening. So it's like
Correct.
go on. So I just prep as a def, and then we concentrate on the example of Naira. That I prep it all. And anything
Yeah.
else you want to do, we'll do that way.
So hi Pallavi, thank you for accepting our invitation to be host on this podcast of Dhirubhai Ambani School of Law. I'm glad that we are able to speak almost like sometime. I remember we started our conversations on sanctions and compliance way back in 2015-16. It's almost a decade away. But at that point in time, the energy levels were very high in terms of putting in place some sanctions compliance framework within some of the banks that we have worked for. But of late, what I am seeing is with Trump administration coming in second time, there was renewed discussion in terms of sanctions, tariffs, and whatnot. Like you will see every day, the front lines occupy the topic of sanctions. So just curious to know, since we are there in the profession for the past 15-20 years, what has suddenly changed in the last 2-3 years in terms of sanctions, and why does it matter to legal professionals like some of us would be listening to this podcast?
Great, Shrini. I believe sanction is a word which has become now a common man vocabulary. It's no more a topic or a word which is restricted to the room of the compliance world. It has a good and bad both, but let's talk about a step back and just talk about what exactly the sanction means, and then we can go about the what is exactly the pattern we are observing in current scenario. So sanction is basically a restrictions can be imposed on the both the sides of the assets, which is tangible and intangible. And in the assets, we mean is related to the hard currency. It can relate it to the matter of the assets, or it can be of a goods and other things. In the intangible format, it can be an insurance, it can be service, and it can be any kind of a designs and other things as well. Now, further, just to put a structure to it, what exactly the program contains? The program contains can be possibly a targeted country, targeted individual, or an entity. To give you an example, from the country point of view, we can see that the targeted has been Iran or North Korea in the current domain. And when we talk about a person, you can think about the terrorist organizations or an individuals like Osama bin Laden. And then you talk about an industry which is sectoral. It also can be possibly a Russia and energy. So it's a sectoral sanction. It is not a comprehensive on the country itself. Now, when we go further, what exactly the categories it can be, executive orders can be published. So it can be in the form of the primary sanctions, which can be an individual, an entity, or we are referring as a country. And they are specific for a reason, and it can be lead to their international policies, or it can be, the UN level of the common purpose of protecting the, the community from the standpoint of the terrorism financing and other related impact of human trafficking and so on and so forth. When it comes to these secondary sanctions, they are only being applied to an entity or to a particular organization or individual. Those are the ones who are doing the business with the sanctioned individuals or entities or a country. We see that right now coming to our home in India itself, which is more on the secondary sanction. We'll dwell with it little later, but that's the overall context, just to debrief. Now, what's changing? I believe the biggest change is the trade. There's a seismic change of the power. We are seeing it in the economic power domain. And that's what it is leading to a geopolitical condition. And as I explained earlier, the sanction is one of the tools which is being used for the security of your own country, sanity or security for the other purposes as well, or it can be from the economic benefit, or ensuring the other country which they're targeting for a specific behavior, the economic loss will happen. Before I delve further, I also want to disclaim it. This is all my personal views. It's not representing the Dow Jones views. So it's,
Perfect.
yeah, we being both a passionate economic students lover, like to discuss this topic and the framework as a best case studies. Yeah, over to you, Surya.
That's interesting in terms of the scope of the sanctions, starting from primary, secondary, and in terms of the targets that we're talking about, either it could be a country or an industry or a specific individual. But of late, like earlier, when in the compliance domain, we used to refer to the sanctions lists, as we call, where these executive orders get summed up, and we need to focus in terms of our screening. Earlier, the focus was more in terms of the individual and the entity or the industry, which is, I think, primarily called as a primary sanction. But in the recent times, we are hearing more of the word secondary sanction, and in some companies which are like based in India are also getting hit under the US sanctions. So let us try to understand or unpack what this whole animal called as secondary sanctions, and why do companies in India, which are not in the realm of the sanctions target, but still need to be worried about that.
Yeah, that's true. In this context, we have to also look into there are already in executive order programs. So the majorly we are coming under the same economic supply chain aspect of it, and being on a very neutral ground, we are observing it because the India as a country has a different supply chain mechanism, and being one of the fastest growing economy, they have to look into their economic interest first, and therefore their international policies differ from the other countries' international policies. And therefore, there are some kind of situation where the thin line and it is coming into such situations. The classic example is currently we are observing that yes, we have a historic nature of working with the Russia on the trade policy point of view as well as on the defense point of view, and there is a specific areas like oil and gas which is a requirement of an India to be get supplied from the rest of the world, and therefore there are the initial areas where the India had depended on the Venezuela. Then there is a sanction program came, and there was a changes happened, and then it got into an attention from the Russia point because of their own interest and the economic making more sense. They took a decision by surveying in the market to do those jobs. But then in the in between of it, the India is also very big partner to US, and therefore there is an element of the laws which has been important for the US and US allies are also expected to be adhered by to India as well. Now the ecosystem of India is also very much, I would say, layered with the US ecosystem because of the financial ecosystem. You can say our banks operate with the US banks operate. We do the currency exchange which is on the US. There are maximum trade happens in the US dollar itself. So we are touching the ecosystem of the US, and hence the policies of them to be adhered by. Now there are some reasons. There are the organizations those have been got targeted into the secondary sanctions because of their track record of operating with those sanctioned entities, which has been clearly coming under the Russia-Ukraine sanctions order itself. We are not surprised because of the natural transactions lead to such actions, and therefore it is coming up as a part of the structural process. Even to go a little bit detail, in 2017 is the time when there is a ownership change of the few companies happen in India, where those got owned by the Russian entities, but they were below the uh, benchmark of the 50%. So for the OFAC sanction rules, it's technically either an entity has to be a sanction, and if it is a sanction, you shouldn't be working with them. And if it is anywhere the ownership is 50%, then it would have the subsidiaries, if you're operating with them and if they are 50% owned by the sanctioned entities or individual, then also you cannot do business with them. It's an aggregated rule also. By the way, Srini, there is an expected to be this same 50% will be moving to BIS 50%. That means the gamut of the companies which is getting restricted will be only increasing, and that will increase the burden of the due diligence and operational work as well. But sticking to the same point, so there it was a slightest change. There was a ownership happened at 49.13%, and therefore that entity never appeared. An Indian entity never appeared as an sanctioned entity or the under the OFAC 50% rule point of view, the majority rule. But now, because of the various transactions of track record, it is coming under the secondary sanction because they are dealing with the sanctioned entities or their subsidiary itself, and hence this is coming as a subject which is being a concern, being our geopolitical relation with both the countries are equally important.
So I get it. I think for the layman or for the people who are just started tracking this sanctions domain for last few years, the things appear to be slightly complicated because the number of people who are getting added to the sanctioned list and maybe the sanctioned individual list is getting day by day increased, and also the scope of the targets in terms of earlier it is only an individual entity or an industry, but you get now different type of transactions. It could be a debt, it could be a sovereign debt, it could be an entity doing a primary or a secondary market transaction. So there are multitude of things that are getting covered under the sanctions. So earlier, the job of a compliance officer pretty much it could be easy because you can download those lists, which are like manageable lists, and then you can do the screening. But now, with these number of sanctioned entities and individuals being so large, I think according to one count, during the previous decades, between 2000 to 2020, or maybe 2016, the total number of entities and individuals should be somewhere around 2000 or 3000, which is according to like the total number of entities that get covered. But the same number, if you see in the last 3-4 years, has actually crossed. So whatever the number of entities sanctioned in the previous decade are the number of entities that are getting sanctioned in previous 1 or 2 years, which means that the scope is getting increased. So the only question I would have is basically how do we keep a tab of whatever is happening on a day-to-day basis in terms of technologically, because it is not humanly possible for us to keep tab of everything that is happening. So how does technology fit into this puzzle of sanctions in terms of keeping ourselves abreast and also making sure that our entities that we work for are really compliant with respect to the sanctions restrictions?
I fully agree with you. I believe the volume is been growing in both the sides. One is the restricted countries or the restricted companies, or even the restricted goods are also coming into the picture. So it's not only the individual entity and country, it is going up to the goods level. So there is a lot more is getting added to. And the other side, the supply chain dependency of the India because of the growth they are taking up is been just growing massively. The number of jurisdictions they are now having the supply chain is massively more in the past 5 years in comparison to the last 10 years itself. So it's a kind of a situation that both the sides, the volume of the third parties engagement and the volume of the third parties getting restricted are just growing at a rapid speed. So it is really not possible humanly, and therefore even it is not possible for the organization to put a unit to only track them and create a database of it, because that is not their major forte is. The major forte is the core business they are doing with. What they would like to do it is to be fully compliant with, and for them to be fully compliant with, they would rather lean on the structured technology or a data which would be having such professionally arranged and updated information. As I was just starting up the conversation with you, that yesterday night I was just making the notes for this podcast, and in the night itself, I got another new names added on the vessel sanction as well as the others in this just in few hours itself. So this is a speed which we are working towards, and hence it is required that the speed, the scale, and the ability of identifying it, what is a risk we are sitting towards. Once we will able to identify, then we possibly will have more proactive measures to do perform business with. So to give you a perspective, yesterday I was in one of the conference and we were discussing about the same thing, that in the current domain, that every organization had the ERP system and the maximum third parties comes over there. But then there is a customers also, because it's not only the third party of the vendors, we have to look after the customers as well. So how these two part of information should be speaking to each other, and then giving you a one scale document which talks about it, what is the kind of risk you are sitting at. And then on top of it, it should have the dissection of the which of the countries it matters to. Because it is not only the OFAC, it is the BIS, it is the UK, FSA, and then there is the others as well, which is just layer it further. So the structure of an information need to be in a manner that can be ingest and can be used in a real environment process itself. And that is where the compilation of information in a consolidation format is very, very important. Otherwise, it can lead to a lot more information and not a conclusive steps to be taken forward. I can talk a little more about it, Shini. It is a subject which we both can speak like an hours. I can leave it to which one you want me to dive in detail, and I can take it up from there.
No, I think in terms of the dimensions that you have put across, the way to look at it, whether it is the customer side and whether it is the third party, that putting into one bucket of the story. Second, in terms of the entities and individuals and the goods, that is the target part of the story, and the context that you have mentioned. I think in three of the domains, there is a need for us to do compliance in a structured way, which cannot be humanly possible. Definitely, we need to rely upon the technology. But the more interesting dimension that I always see when I talk about technology is that machines do these jobs much better. Like, we need not worry about tracking ourselves, the websites, and we need not wake it up in the times when these sanctions lists get announced. So we'll get the kind of things in a matter of seconds. The updates and the screenings happen in a matter of very quick time, and the updates also in terms of what needs to be done as a kind of a straight through processing. So there are workflows that are organized. So everything is driven by technology. Now, in that context, Pallavi, what do you think the role of a human compliance officer or a human lawyer, or as a compliance as a profession or a legal as a profession, what do they need to do if everything is tracked by machine, if everything is done compliance by machine? So where do these compliance professionals and legal professionals stand to compete against machines who can do a better job in sanctions compliance than humans?
Yeah, nothing less I can expect from you, Srini. The question is so true. I would like to draw some more parallels here. And I would like to quote it. Yesterday, I was listening a podcast from the WSJ, which was talking about the number of the contracts of the AIs are increasing, but at the same point, and the lawsuits against them is increasing too, which is on the content side of it. Just to give you a perspective. Now, when you have too much of data, and then you have too many information flowing from together from the machine, there is an importance to it, but at same point in time, it cannot be even consolidated without having the human interface to it. One of our chief data team, who's like a head Ingrid, she often says this: it's an augment intelligence which will be required in the time of the data collection, and at same point in time in the processing of it as well, because it's only machine can consolidate an information, but it cannot make the insights out of it. That is this a real the same names you are looking at it, is this information which will have an implication, and if there's an implication, what is a risk based approach is required. Automating that, it's not a cookie cut model we can apply, because as you also, and me knows this, that every sanction program have a different underlying points, and until we will not go through that, the risk based approach cannot be designed towards that. And once we have the risk based approach, the human intelligence is always required to identify that, or to take the necessary approvals or perspective of taking those actions. For example, if there is an entity which is a very, very important strategic partner to you, And that is one of those unique suppliers. And we can give a classic example of a Taiwan. The semiconductor of 34% of the production is only in Taiwan. Do you think that it can be even replaced by any country in that short period of time? So that is a kind of dependency in some of the areas we really have, and it leads to some kind of a complication, no matter what we say in that domain. And therefore, the risk based approach can only be designed by the human, it cannot be from the machine. And therefore, the legal expert and the compliance experts are always required. And then there is another part to it. I believe it is an RBI or someone, I can't recall exactly where I read it, where it mentioned who will be taking the accountability. So if there is a mistake happen, you cannot make the machine to be accountable that this is a violation has been conducted by a machine, and because of that we have not done any sanction violation. It's not the case. It's basically the human is involved in implementing it, and processing an information and taking a decision is very much important part of it. We cannot blindside it. It require at the control mechanism, it require in different checks and balances point of view, and it is required at an advisory level also. Even now, the businesses, and I'm observing that, is getting more aware about it. That the amount of the challenges is coming up in supply chain. I would also like to quote it to an extent that I was talking to you, I think offline, where I mentioned that I believe it's a Singapore Prime Minister who mentioned that the seismic changes are happening so often that we really don't know the vessel which is departing from Singapore today is, and the goods which is carrying, can this also offload after a 1 week to US port, because there's a possibility that good or that entity can get sanctions. So it is that much change is happening. So human interference will be always required, and that is a necessary part of it. I would say the augment intelligence will move. We cannot dismiss the importance of technology, AI, but at the same point in time, it will only be an extension to our knowledge. It cannot be a replacement to our knowledge.
No, I think this is fantastic. Like while we can equate machines to an artificial intelligence, equating humans to augmented intelligence, and that cannot be replaced with just the machine algorithms. The augmentation comes with maybe years of experience of handling the items, and maybe the experience of understanding the market nuances, and experience of maybe looking into the real life context. Actually, that adds the perspective. Maybe that is at a little 30,000 feet level, and maybe a very high orientation in terms of the machine human question. But to be little down to maybe a 100 feet level and to day activities, like very briefly, what exactly are the 3-4 domains, maybe in terms of the organizational context, what are the 3-4 domains where the legal professionals really can work upon in order to hone up their skills in the sanctions compliance? Basically, which areas do you think they need to focus upon in their day-to-day work life working in a financial institution? So what areas that the legal professionals should really look for in terms of sanctions compliance?
Yes, I would say the trade is gonna be the trend, the biggest trend. If they can really understand that area much deeper, and it is not only the sanctions, it is also require the export import control restrictions also, and those restrictions have a multi-layer approach. So if they will keep themselves updated about those aspects of it, what are the changes are happening and why it is happening and what is an impact to it, then their ability to take the decision or advise someone will be much greater applications to it. Because it's not that the people don't know the laws, it is about that how you navigate the business, because end of the day it is a business oriented decision is supposed to be required. The legal need to have that approach towards the risk based approach in that itself. The second area, which is picking up a great part of then importance, is the how to conduct an efficient due diligence. Because there is a due diligence is required, but we were discussing about it in yesterday about it. How we will take as an approach? Will that be just a basic level of an approach, just to do it for the sake of doing it, or to understand that deep dive approach, that how to perform that. And for that you probably should be good if you have little more forensic information and forensic skill sets as well, because given the fact that the data volume will be only growing from here, it is not going down. So you should have the ability to use the technology in favor of you, so that you can really can make insights out of it and bring more value out of it as you progress into your professional career itself. The third element I would say is there are several small certificates which is a very handy in nature, but it gives you a really good domain knowledge, and that adds to your mainstream work, and that allow you to stand apart. So there are the international certificates as well as domestic also. I can share the list of that, and those are really very good. I personally have also done it, and you and I actually have discussed this matter a lot. I always look for as well. So this is the few aspects I can share it about.
I understand the demand side you are mentioning about. Either it could be the due diligence stage, whether you are onboarding a customer or onboarding a vendor, or maybe onboarding your new any other counterparty that you can talk about, or whether you are doing a due diligence on any deal that you are making, for instance. So that is the key context in which I think the legal professional skill set so far in terms of analyzing the document needs to be a little more augmented with the business sense, and also the broader perspective of the global trends in terms of either the sanction side or in terms of the way the trade and the supply chain operates. So that part is clearly understood. But one common excuse that most of the folks, when I interact, especially when I talk to students in law colleges and maybe the early stage professionals in legal career, so when I speak to them, they treat sanctions is something like a kind of an international topic, which means that any company in India which has got an international what do you call engagement, either in terms of trade or in terms of any other financial transaction, then the sanctions is very important. But not many companies really have that kind of an international or a global presence. So when we talk about these technologies and when we talk about these what do you call the tools that we tend to use in a domestic context, like do you really see any kind of a usage of either the tech or either the legal profession in terms of the domestically focused entities? So to what extent they need to be mindful of some of these trends, even though they don't have an international presence?
Okay. Even though the organization doesn't have the international operations, but they are horizontally or vertically will be linked to one or the other international organization. It's hard to believe it's none. There is a possibility that as the organization is of, let's say, SME side, and as it grows, the operations and the scale of that nature will grow. And if one would not have these skill sets or the ability to visualize those risks early in nature, it can be a reactive approach, and that possibly can cost more than the proactive aspects of it. So keeping yourself blind spot, it can be a blind spot which you you have to bear some cost some one day. That's a one way of looking at it. The other way of looking at it is that how about putting it in a context, the context of such nature. You are not having the international market as a focus right now, but tomorrow if you have to sign in a JV, and which I'm observing a lot is happening, let's say in Chennai, and those JV, the counter entity is actually a Japanese entity or some other entity, then you probably should be having your basics right, because in every document you are gonna take an ownership of it, that you would not be doing business with the sanctions entity. And given the fact that we are also a UN member, we also have that overlay of the UNSCR point of view, which sits in everywhere, including the financial institution to the corporate level. So those aspects do see a merit in it. The another part of looking at it is, how about the export and import and the logistics part of it? Would you see those areas will never touch you? Maybe it's just a matter of time. And the moment you cross the sea, there is aspects which you should be aware about it. The earlier you do, the better it is.
Get it, get it. I think we're not reaching towards the fag end, but I would like to make it a little more interesting for the audience to take away from like the professional experience that you have carried, like a lot of this stuff that we have discussed in terms of the domain, the risks involved in terms of the human augmentation that is required. So I'm glad that we spoke all about that. But drawing from your personal experience, now I have been seeing you operating in this space for almost like 15, 20 years. Someone to really get into a single domain as a kind of a super experience for those many years is always a kind of a daunting task. So somebody eventually gets bored. So to our audience and to generally to me, just narrate maybe 3 high-level bullet points in terms of what makes you to feel energized to do the same role of the sanctions complaints even today. Like, what are the 3 exciting points that you feel that you still want to pursue this sanctions domain as your career choice?
I see. That's an interesting one. The first thing is the curiosity to know why it's happening and what is the reason behind it. And the deeper we go, the more we self realize that how little we know and how much more we want to know. So that's the first thing. The second part is that this exposure has taught me a lot of lessons that how we can take a better decisions in general and draw a better analogies while going through the process of taking a decisions. So it's not only just to take a decision, as a process is very, very important, and this element is a very important part of it. I would say that if you are here to make a long standing career, then it is better to invest into one or two expertise domain rather than jack up everything and not able to get a one thing right. So it's up to one personal choice again. So it's that's what I see that. The third is being a passionate economic student. This always excites me because it's an international economics and you can really relate it very well, that the trade and the sanctions goes hands in hand, and that's where it goes more interesting for me. Thanks you very much, Srini, for asking this question to me.
In fact, I feel curious because the complaints is always considered as a little boring job. And at one point in time, I was not able to attract as many young legal minds I used to do. The way we can attract a chartered accountant or an MBA or a kind of a finance professional to complaints domain, we couldn't attract much of the legal guys there. But at this juncture, in the last few years, I see a lot of interest, and also there is a need for more and more legal professionals also to join the sanctions compliance domain. And the reason why we wanted this dialogue amongst us is basically to highlight the intersections between the legal profession, the technology part of it, and the emerging demands in this space where they can contribute. And thanks that you brought out the subtleties of the individual aspects of the sanctions compliance. And to the audience, I would also like to say that there is a kind of a resource that we can share as a part of this podcast hosting. Some of the certificates that Pallavi has mentioned that individuals can pursue to hone up their skills in a professional context, and some of the interesting articles which will give us an interesting insight into how sanctions compliance is always an exciting job. I think with the inputs Pallavi shared and together with the readings that we can provide, I hope some of the young minds and also the experienced professionals would find it interesting to deep dive into the sanctions compliance more and more, because the way the trend is happening, we will require more professionals to be joining this domain, and the discourse in terms of what is good for the country also has to be in a more informed manner. So thanks, Pallavi, for initiating this dialogue, and I'm glad that we could make it today and speak about it. Thank you.
Thank you so much, Srini. Thank you for this
Thank
opportunity.